So another one I've got for you is paid time off. This is a decision out of the Third Circuit. We are in the Eighth Circuit Court of Appeals over here in Missouri. Illinois in Indiana are in the Seventh Circuit Court of Appeals. This was a decision out of the Third Circuit Court of Appeals where the court decided in an issue of what they called an issue of first impression that the term salary is used in the FLSA does not include fringe benefits like PTO. And the significance in this case is that an employer had docked an employee's accrued paid time off for failing to meet productivity targets. And the court said that is legal, not, notice I did not say
that
illegal.
Does
I
surprise
said
me,
it is legal because PTO is not part of an employee's salary under the Fair Labor Standards Act. So we all know we've been talking about the FLSA a lot on the program the last few weeks. We all know that there are limitations on an employer's ability to dock the salary of an employee, of an exempt employee's salary, because if they do that, they could jeopardize the exemption and the employee could be reclassified as a non-exempt employee, meaning the employee would be entitled to minimum wage and overtime. The Third Circuit here, again, I want to make it very clear, saying that an employer is allowed to dock the PTO because that is not part of the employee's salary.
All right. Well, that's going to be an interesting ruling. I got a bunch of questions that come to mind. We'll save those questions for another day, but let me queue them up for you. Right? Questions like, are we talking about what if it's accrued, it's on the books, and it's owed to me by policy? And I know you're going to talk about the Illinois law, and you're going to tell us about their mandatory time off. And is this the same or different? And maybe you can answer that one a little bit, but I'm sure our listeners are going to have questions centered around this one.
Yep.